On May 24, 2022, a gunman entered Robb Elementary School in Uvalde, Texas. 19 teen children and 2 teachers would die that day, but the tragedy didn't end when the shooting stopped. For 77 minutes, hundreds of law enforcement officers stood in the hallway while children called 911 from inside the classroom. The question that followed would reshape how we think about police accountability. This is Case Files Explained, and today we're examining the trial that tested whether an officer could be held criminally responsible when the entire system failed around him. Adrian Gonzales was 52 years old, a school police officer for the Uvalde Consolidated Independent School District. On that Tuesday morning, he was one of the first responders to arrive at Robb Elementary. 3.5 years later, he sat in a Corpus Christi courtroom facing 29 felony counts of abandoning or endangering a child, 19 counts for the children who died, 10 for those who survived. The prosecution's theory was simple. When children are dying, when you're trained to stop the threat, standing in a hallway isn't just a failure of duty. It's a crime. The defense countered with something more complicated. In a crisis where command broke down, where orders were unclear, where hundreds of officers did the same thing, how do you single out one man? To understand this trial, you have to understand what happened at Robb Elementary, not just the shooting itself but the response that followed. The gunman entered through an unlocked door at 11:33 in the morning. Within 3 minutes, officers arrived on scene. They heard gunfire. They knew exactly where the shooter was. Standard active shooter protocol, the training every officer in America receives, says one thing clearly. You move toward the gunfire. You stop the threat. Every second counts. That's not what happened in Uvalde. Instead, officers gathered in the hallway. More units arrived. State police, border patrol. Eventually, nearly 400 officers would respond to the scene. And for 77 minutes, while children bled on the floor of connected classrooms 111 and 112, those officers waited. Some looked for keys that were never needed. Some searched for tactical equipment. Inside those classrooms, children were calling 911, whispering to dispatchers, begging for help. One child said, "Send the police now." The dispatcher said they were coming. At 12:50 p.m., 77 minutes after the shooting began, a tactical team finally breached the classroom and killed the gunman. By then, 21 people were dead or dying. The investigation that followed was damning. A Texas House committee called it an overall lackadaisical approach. The Justice Department found cascading failures at every level of command. But investigations don't satisfy grief, and reports don't bring accountability. The families of Uvalde wanted more than findings. They wanted someone to answer for what happened. Pete Arredondo, the school district police chief, became the initial focus. He was the on-scene commander. He was fired. But criminal charges against him wouldn't come until later. Adrian Gonzales was charged in June 2024. Unlike Arredondo, he wasn't in command. He was a line officer, one of many who stood in that hallway, so why was he singled out? The answer may lie in his training. Gonzales was a school police officer. His entire job was protecting those specific children. When the threat came, prosecutors argued, his duty was singular and clear. The trial was moved to Corpus Christi, about 200 miles southeast of Uvalde. The judge ruled that finding an impartial jury in Uvalde would be impossible. The wound there was too fresh. Jury selection began on January 5, 2026. Hundreds of potential jurors were screened. In a case this prominent, everyone had an opinion. Finding 12 people who could be fair was itself a challenge. The prosecution built their case around one central question. When children are dying, when you've been trained to act, is standing by itself a crime? Under Texas law, abandoning or endangering a child is a state jail felony. It requires showing that someone intentionally, knowingly, recklessly, or with criminal negligence placed a child in imminent danger. The prosecution argued Gonzales did exactly that. By failing to engage the threat, by waiting in that hallway, he abandoned the children to their fate. His inaction endangered them. Witnesses from that day testified. a former Robb Elementary teacher, took the stand. Her voice cracked as she described hiding children, hearing gunfire, waiting for help that took too long to come. She said the words that would echo through the trial. "It haunts me to this day." For the families in the gallery, those words carried the weight of everything they'd lost. The defense presented a different picture. Gonzales's attorney argued that his client followed the orders of his superior officer. He didn't make the command decisions. He did what he was told. In any tactical situation, the defense argued, line officers follow the incident commander. Arredondo made the decision to treat this as a barricaded subject rather than an active shooter. Gonzales followed that lead. It's called a Nuremberg defense for a reason. "I was just following orders" has a troubled history. But in the chaos of an active scene, the chain of command exists for a reason. The defense also pointed to something uncomfortable. Nearly 400 officers responded that day. If Gonzales committed a crime by waiting, did they all? Why was he alone on trial? The prosecution countered, Gonzales wasn't just any officer. He was specifically assigned to protect these children. He knew the school. He knew the kids. His duty was particular, not general. The legal question underneath all of this is genuinely difficult. When does institutional failure become individual criminal liability? When do bad decisions become crimes? Police officers rarely face criminal charges for failures to act. The legal doctrine of qualified immunity shields many decisions made in the line of duty, but that applies to civil suits, not criminal prosecution. This case tested new territory. Could Texas's child endangerment statute, typically used against parents who leave children in hot cars or neglectful caregivers, apply to a police officer's tactical decisions? After more than 7 hours of deliberation, the jury returned with their verdict on January 21, 2026. On count 1, not guilty. On count 2, not guilty. 29 times, the same words. Adrian Gonzales walked out of that courtroom a free man. The families of Uvalde watched from the gallery. Some wept, some left in silence. None of them got what they came for. After the verdict, victim family members spoke to reporters. Their grief was raw. Their anger was focused. They felt the justice system had failed them again. The legal reality is this: juries are asked to decide guilt beyond a reasonable doubt. In a situation this chaotic, with command structures this broken, proving that one man's specific inaction caused these deaths. That's a high bar. The defense succeeded in creating doubt. Not doubt about what happened, everyone knows what happened, but doubt about whether this one officer, under these circumstances, could be held criminally responsible. So, what does this verdict tell us? It suggests that when institutions fail catastrophically, holding individuals criminally accountable becomes extraordinarily difficult. The system shields its own, even when the system is broken. Some legal experts argue that's how it should be. Criminal law is a blunt instrument. It punishes individuals. Systemic failures require systemic responses, policy changes, training reforms, institutional accountability. Others see this verdict as proof that police accountability remains an illusion. When officers can stand by while children die and face no criminal consequences, what message does that send? Other officers still face charges. Pete Arredondo, the former school district police chief, awaits his own trial on similar charges. His case will test the accountability question at the command level. For families navigating the aftermath of mass violence, there's a painful reality here. Criminal trials may not provide the closure they seek. The justice system wasn't designed for accountability at this scale. Civil lawsuits offer another path. Several are pending against the city of Uvalde, the school district, and various law enforcement agencies. Civil courts have different standards and different remedies. Policy reform may be the most lasting response. After Uvalde, Texas changed its active shooter training requirements. Other states have reviewed their protocols. The lessons learned are being codified, slowly. If you found this case significant, consider subscribing. We examine cases like this every week, looking at where the justice system succeeds and where it falls short. Understanding the legal limits of accountability matters. When we demand justice, we need to understand what justice the law can actually provide, and what falls outside its reach. The Uvalde response failures weren't hidden. They were documented, investigated, and condemned at every level. But documentation isn't punishment. Condemnation isn't accountability. 3.5 years after 19 children and 2 teachers died at Robb Elementary, no law enforcement officer has been convicted of any crime related to the response. That's the harsh arithmetic of this case. 21 dead, nearly 400 officers on scene, 0 convictions. For the families, that math doesn't add up to justice. The question this verdict forces us to ask isn't just about Uvalde. It's about every institution we trust to protect the vulnerable. When protection fails, who answers? Following orders is not, by itself, a defense to criminal liability. The law has recognized this since Nuremberg. But proving that disobeying orders would have saved lives, that's where cases fall apart. Adrian Gonzales' defense succeeded because the jury couldn't say, beyond reasonable doubt, that his specific actions or inaction caused specific harm. In that chaos, causation dissolves. The family's attorney called the verdict a failure of justice. The defense attorney called it the right result under the law. Both statements can be true at the same time. Consider this: every active shooter protocol written after Columbine says the same thing. Immediate action saves lives, waiting costs lives. The evidence at Uvalde proved this once again. The policy responses to Uvalde are ongoing. Texas now requires annual active shooter training for all school district police. Other states are following. Whether these reforms prevent the next tragedy remains to be seen. What happened at Robb Elementary was not ambiguous. The failures were documented in real time in 911 calls, in body camera footage, in radio traffic. Everyone knows what went wrong. The question was never what happened. The question was, who pays the price? This verdict suggests that in cases of systemic failure, the answer may be no one. At least not criminally. The families of Uvalde have been through investigations, congressional hearings, civil litigation, and now a criminal trial. They've testified and relived their trauma, and still no one has been held accountable. Adrian Gonzales is not the last officer who will face charges for what happened that day. Pete Arredondo's trial is still ahead, but this verdict sets a difficult precedent. What this case reveals is the gap between what we expect from those sworn to protect us and what the law can actually require them to do. That gap is where tragedy lives. For 19 children and 2 teachers, for their families, for a community that will never be the same, this is Case Files Explained. Thanks for listening.